Hi, this is Jim Cunningham. We're going to talk about estate planning tips for a $1 million estate. I would say that planning for $1 million estate, what we're really going to be focusing on is planning for incapacity, meaning that is if you are unable to do for yourself, as my Uncle Delbert from Arkansas says, if you're not able to do for yourself and someone else has to do for you, that means you're incapacitated. Avoiding probate court. You really want to, especially with an estate of $1 million, you really want to avoid probate court because it can take a significantly larger percentage of the estate than it can for a 10 million or certainly larger estate. We're going to talk about postmortem transfer of assets. We're going to talk about control of an inheritance. Control of an inheritance, you may not have thought about it in that way, but it's very important, and we'll discuss that. We're going to talk about protecting an inheritance from creditors, predators, and divorce. Obviously, that's important. You don't want a future ex-son-in-law or future ex-daughter-in-law getting what you've taken a lifetime to accumulate, as well as the day-to-day management of the inheritance. I will say if you miss any one of these, your plan can fail, and failed plans end up in probate court, and that's not where anyone wants to be, and that's why you're watching this video or listening to it. Even $1 million estates need protection. So if we're doing this live, if you're watching this on YouTube, you can go ahead and subscribe to our YouTube channel, and you can click the little bell and it will pop up in your feed. You can also share this video with friends and family. So we encourage you to share that as well. I will be speaking, we're recording this in January of 2026. I will be speaking in San Francisco, February 23rd of 2026. At the Aging and Longevity Summit, hosted by the San Francisco Chronicle. The keynote speaker is Rick Steves. It's actually, I don't think that's a picture of Rick Steves, but he's the travel guy on public TV. So I will be there February 23rd. This is a disclaimer. I'm a lawyer. I'm talking. My lips are moving. Words are coming out of my mouth. When I use the word you, I do not mean to imply there is an attorney-client relationship. So I'm just trying to explain a concept with hopefully a little bit of, and keep your attention engaged with a little bit of humor as appropriate. But really, this is not something where you want to watch this video and say, well, Jim showed me how to do all this legal stuff, and go out and do it. You definitely want legal advice. I'm Jim Cunningham. I'm a partner at Cunningham Legal. I have over 30 years experience as an attorney. We have offices throughout the state of California. I'm a certified specialist in estate planning, trust, and probate law, securities insurance licensed, and a pilot single engine land instrument rated, although I'm not currently current on my flying. These are all the attorneys at our firm. We are about all things peaceful transfer of wealth from one generation to the next. And let's start with, what is a $1 million estate? Now, you may think, Jim, well, this is pretty easy. You have $1 million in the bank. Well, it's very important to understand that an estate, what we're talking about and what the federal government looks at, sometimes a $1 million estate is more than $1 million. It's because your estate includes everything owned at death, plus assets controlled or effectively keeping strings on those assets. So obviously, your house is included in your estate, all bank and brokerage accounts included in your estate, business interests, you may not really be thinking about that, that is included in your estate, retirement accounts, a lot of people just don't kind of include this. They go, well, it's not in my trust, and we'll talk about why it's not in your trust, and personal property. This also includes jointly owned property. So if you own property as joint tenants, for example, with a business partner, maybe you bought that property together, and that business partner ends up with the property when you die, that joint tenancy property is included in your estate, even though your family doesn't get it. So it's very important to understand that. In fact, it's typically the full value of the joint tenancy property, unless you can prove that you did not contribute the funds to purchase the property. This does include life insurance on a decedent's life. So a decedent is a person who dies. That's the legal term that we use, a decedent. This includes life insurance on a decedent's life if the proceeds are payable to the estate, or you retain power to change the beneficiary, borrow against the policy, surrender it, or otherwise control it. So broadly speaking, unless this life insurance is owned by another person, maybe your kids, or it's in an irrevocable life insurance trust, the death benefit is included in your estate. This includes certain annuities, essentially annuities that continue on after you're gone. So if you buy an annuity and die a year later, oftentimes there's a 10-year term certain. So those 9 years of future payments is part of your estate, and contract rights tied to a decedent. that produce survivorship or payment rights that I mentioned. Certain lifetime transfers are included, and they're pulled back into the estate. So, if you give away your house and you continue to live in that house, that would be an example. So if you're a wealthy person who says, wow, I want to get this beach house out of my estate, I'm going to give it to my kids, but I'm going to keep using it. Nice try. The government pulls that back in, and that can be a very onerous on larger estates. But we don't see this so much in smaller estates, and it's really a non-issue. And we'll talk about why it's a non-issue for a smaller estate, certainly when it comes to estate taxes. This also includes property over which a decedent held what is called a general power of appointment. Now, a general power of appointment, sometimes a person is a beneficiary of a trust, meaning maybe their parents died and they left property. Maybe they left $500,000 in a trust. And that person who is getting the benefit of that $500,000, it's not in their name because it's in a trust, has something called a general power of appointment, which basically allows you to say who gets the property when you die, if you're the person receiving that property. That is something that is included in your estate. So it's not necessarily an asset that's in your estate. And we do see this more often than you might think, and even on smaller estates. So it also includes trust assets if the decedent retains sufficient control, enjoyment, or revocation rights that cause federal estate tax inclusion. All that means is your living trust, the assets in your living trust, are included in your estate. So you're not going to bypass estate taxes by putting assets into a living trust. There's no easy way. So let's look at Wanda. We're going to talk about Wanda a lot throughout our time together. Wanda owns a home valued at $800,000, kind of an average home in California. In fact, the average home in California is about $800,000, maybe $1 million, depending on where you're at. She paid $300,000 for this property. Now, she's protected by Prop 13. We're going to talk about that a little bit toward the end. But Wanda's protected by Prop 13. Maybe her property taxes are $4,000 a year. Her home's worth $800,000, and she has savings of $200,000. Wanda thinks she has $1 million estate. And for probate purposes, she's absolutely right. She has $1 million estate. But Wanda has a life insurance policy with a $500,000 death benefit and a traditional IRA of $500,000. So Wanda's probate estate, although it's only $1 million, her estate is $2 million. So her estate for federal estate tax purposes, and really that's kind of the guiding light, the North Star that estate planning attorneys kind of orient everything around, is this federal gross estate where the federal government says, even though it doesn't go through probate, we're going to still count it as part of your estate. So Wanda's $1 million estate really is $2 million, but for California probate purposes, it is $1 million. So this can be confusing for some people because you're like, well, Jim, you're talking about two types of estates. Well, one is for state purposes, for probate purposes, and the other one is federal purposes. And these numbers in this case are different. It's not uncommon for numbers to be different, frankly, in most estates. So there's no federal estate tax. So what aren't we concerned about with Wanda? Well, with $1 million estate, there's no federal estate tax. That kicks in if Wanda had assets greater than $15 million. In fact, if she had assets greater than $15 million, anything over that $15 million is taxed at 40%. That is due 9 months after death. But because Wanda's estate is far under that $15 million figure, there's no estate tax. So we can scratch that off the list. That's a non-issue. Wanda's home while she's alive is subject to capital gains tax if she were to sell that property. So I mentioned she paid $300,000 for the property. If she sells it for $800,000, let's say she's a single filer, there's going to be a $250,000 potential taxable gain. It might be 60, 70, 80,000 in capital gains taxes, state and federal. But if she dies and then her estate or her living trust sells that property for $800,000, her assets get what is called a step up in basis. So this is really a very important point. Some people say, well, I have $1 million estate and taxes are not an issue. Well, that's not true. Because if Wanda said, I'd really like to give this house to my child, if she gives the house to her child, that child gets the low basis, meaning whatever Wanda paid for the property, that $300,000, it's really what she paid for the property plus improvements minus depreciation. Whatever Wanda's number is, like if she were to sell it and pay the capital gain, that number transfers to her child. But if her child waits until Wanda passes away, then that child inherits the property with a new $800,000 tax basis, which means that child, if the property sells for $800,000, does not pay capital gains tax. So very, very important. I think this is probably where this is like one of the tips here. I think people step in it when they make a gift of the home of a highly appreciated home. That can transfer a tax problem to the kids. Wanda's home is subject to reassessment and loss of her Prop 13 taxes. I did mention that she paid $300,000 for the house. Maybe her taxes are about $4,000 a year. That gets lost when she passes away, unless we have some of the two exemptions we're talking about, the family home or family farm, and we'll discuss the family home exemption. The IRA, this is very important on Wanda's $1 million estate. The IRA is subject to both federal and state income tax, applicable state income tax. So if Wanda yanks all the money out of that IRA, that $500,000, she would add that to her 1040 in the year she does that. If a child inherits that IRA and yanks all the money out when mom dies, that $500,000 is reported. Under the current rules, all the money has to come out within 10 years of Wanda's death. So on the December 31 that contains the 10th anniversary of her death, which is really 11 tax years, that money has to come out at the end of 10 years, unless an exception applies for minor or disabled or chronically ill beneficiaries, or potentially a spouse. Cash and life insurance pass without tax. Now, life insurance, cash obviously has basis, so it's going to pass. There's no tax on cash. Remember, we talked, this is not a taxable estate. It's not over 15 million. The life insurance is very important. If you're a business owner and you are deducting your premiums, the death benefit is subject to income tax. Most people do not deduct their premiums. If you're just a W-2 earner and paying a premium, you're probably not deducting it, so you don't have to worry about that. But if you are a business owner and deducting those premiums, the death benefit is subject to income tax. Let's talk about 4 pillars. What are we talking about? 4 pillars in estate planning. We're talking about control, protection, transfer, and management. So control, protect, transfer, manage your $1 million estate. And we're going to take these one at a time because these are separate issues. Give you a sneak peek here. The documents you need to control $1 million estate with proper planning. And a tip here is if you own a home and you live in California, you will likely be needing a revocable living trust centered estate plan. A will is not going to cut it, and we'll see why. But this typically involves a living trust. We'll explain what that is. When you have a living trust, you should also do a will. That will leaves everything to the trust, also known as a pour-over will. Guardian nominations if you have minor children. Beneficiary designations, we'll talk about that. Who gets your IRA when you die? Doesn't pass through your trust or through your will. That is a beneficiary designation at the institutions. Very, very important. We're going to revisit this. Powers of attorney for healthcare, for property, HIPAA authorization, deeds to your properties, and a power of attorney for property. We're going to talk about all these things as we go through the materials together. So, a living trust-centered estate plan. Let's talk about control of a $1 million estate. Now, whether you're a control freak or not, everyone wants to have agency or decision-making authority over what happens to them and their money if a person becomes incapacitated. So if you do nothing, and this is very important to understand because the fork in the road, if you've not done an estate plan and you're trying to decide, look, is doing a will or a trust for me or not? Should I just do nothing? If you do nothing and have a stroke, that will lead to a conservatorship, which is a probate court proceeding, that will lead to court oversight, that will involve delays, and will involve lots and lots and lots of fees and heartache and stress and hassle. Now, having a stroke and being physically or mentally incapacitated, it's not a picnic, right? But what we can do is we can remove a lot of these extra hassle factors. With a proper estate plan, you have a successor trustee that steps in. There's no court, pays the bills, everything's smooth. We're removing that added layer of court involvement and frankly, loss of control, because if you don't, this is very important. If you don't set up a plan in advance, a judge is going to be deciding what happens. Now, you may know this judge, you probably don't. I mean, it's, what probate judge are you going to get? Because it's the probate court that decides. It's very, very important. The disability, this incapacity planning, I think is one of the biggest, I think it's the biggest overlooked aspect of estate planning, certainly for $1 million estates. So what does control mean? Control means naming somebody to act who has legal authority before you become incapacitated. This is in documents. You have to document this, typically with a lawyer. You're going to have, sign a bunch of papers, have them notarized, whether it's the living trust we talked about or the healthcare directive or the durable power of attorney. You do that before the event happens, before the disability happens, before the incapacity happens. With a proper plan, your loved ones can act on your behalf without asking a probate judge for permission. $1 million estate is big enough to create complexity. This is very, very important. in the scheme of things in California, $1 million estate is not considered a large estate. It is not a de minimis estate. It's large enough to create complexity that requires probate court involvement without a living trust in place. If an estate is so small that there's no money involved, it reduces the involvement of the court when it comes to a conservatorship. But if you have assets, so let's talk about this. Wanda suffers a stroke and can't manage Wanda's assets. So with a proper living trust-centered estate plan, Sally, the successor trustee, is able to step in. So Wanda stops being trustee. Sally is successor trustee, assumes the duties of trustee, works with Wanda's investment advisor to properly manage Wanda's portfolio. And Wanda is protected because Sally, the successor trustee, and who's also the agent under the durable power of attorney for property and health care, and we'll talk about that, can quickly step in following Wanda's stroke. No court delays, minimization of family infighting. So what we have here is an example where Wanda set these documents up in advance. So very, very important. Incapacity, again, I mentioned it's not often considered by people in the planning process. They don't really think about it. What do I mean by incapacity? This is not disability. Being disabled is not being incapacitated. What I am talking here is specifically a lack of mental cognition or mental ability to make informed decisions or manage affairs due to a mental, potentially a physical impairment, but the physical impairment is typically driving some type of a mental impairment. Now, someone who's in a coma, are they physically or mentally impaired? I mean, that might be an example of physical impairment. If you have a stroke, so these things kind of come together, but you're unable to do for yourself. As I mentioned, my Uncle Delbert said, if you're unable to do for yourself and someone needs to do for you, that means you're incapacitated. And we're talking mental incapacity. A mentally incapacitated person usually can't understand the consequences of their decisions, which probably describes a lot of teenagers, quite frankly. But it's separate. We have separate standards for medical and financial decision making. So stroke, Parkinson's, dementia, Alzheimer's, mental illness are sort of typical of what we see in our practice. And without a proper plan, this does require probate court to find a person. Failure to plan for incapacity. Here's a tip. Failure to plan for incapacity is one of the top 10 estate planning mistakes. So in the pantheon of estate planning mistakes, mistake number one is failure to plan for incapacity. So what is an estate plan? It's a set of legal documents that helps avoid court disputes, reduces taxes, and ensure your wishes are respected. It is essential for incapacity management, as we discussed, distribution of assets, medical choices, financial management, and avoiding, and we use a revocable trust to avoid probate. So, and I will say, here's a tip. This is really too important for a do-it-yourself or an AI or online or other non-lawyer providers. We periodically sort of test what's this, and they come and go, right? So the latest one, I did an estate plan with them, and I was very disappointed because you think that if you're promoting something on television commercials and through social media, you would have a better form, but the form just really wasn't even up to snuff. So again, I think this is something where you want to go seek out a qualified lawyer. I wrote a book on this. I wrote a book, Savvy Estate Planning, What You Need to Know Before You Hire the Right Lawyer, and we'll put a link in the notes here. This is a book that walks you through all the things that an attorney is going to ask you before you even go to the lawyer's office. Now, you could be in any state, you could be anywhere in the world. The lawyers are going to ask you the same types of questions, right? Who's going to be in control after you're gone? Do you want to leave it equally to your family or not? Do you want to protect it? A lot of attorneys don't ask you if you want to protect it from creditors, predators, or divorce. We do, because that's important in our estate planning practice, is to make sure that the inheritance is protected. So let's talk about the powers of attorney for healthcare, HIPAA authorization, and advanced healthcare directive. So what's going on here? We're staying on incapacity. There's a planning gap. When a person is incapacitated, this means they're not dead, but they're not able to handle their own affairs, okay? You're going to have a living trust is going to be the vehicle that manages assets that are in the trust. We'll walk you through what a living trust means, but if somebody's incapacitated, this living trust, let's say it holds the house. The successor trustee deals with the house. Sell it, pay the taxes, whatever you need to do. Not sell it, right? The healthcare directive empowers a person to make healthcare decisions for somebody who can't make them for themselves. A financial power of attorney gives authority to a human to act on behalf of the person who is incapacitated for all those things that are not healthcare and are not in the trust. Now, we gave an example of Wanda earlier. She had a house and a retirement account. Well, the house is in the trust. The retirement account, Wanda doesn't transfer the retirement account to her trust while she's alive. A lot of people think you do that. But if Wanda has her stroke, let's say she becomes incapacitated, Sally, her agent, who's also successor trustee, but Sally is the agent under the durable power of attorney, uses the durable power of attorney to deal with Wanda's IRA. So if you're watching this video because you're a Sally and you're helping take care of a Wanda, the reason your living trust doesn't help you with the IRA is the IRA is not and should not be part of the trust. You would use the durable power of attorney for that activity in terms of investment, talking to the investment advisor or maybe making a withdrawal for paying for healthcare or whatever it is. That's done on the durable power of attorney level. So very, very important distinction. The uniform statutory form power of attorney in California, we typically use this in, I don't want to say all of our estate plans, but the vast majority. One problem we find in practice, and again, if you're watching this video and you go, I'm watching this video because I went to a bank and they said, we're not going to honor that power of attorney. You had to do a bank power of attorney. The uniform statutory form power of attorney, which is a 2-page form, it is in the probate code. It is readily downloadable from third parties. We adapt it for our own purposes. If a bank does not honor it, a court must award attorney's fees. Let me explain this another way. Only the uniform statutory form power of attorney gives you, right, the individual, the hammer with the bank to say, listen, if you don't honor this power of attorney, you have to pay my attorney's fees so that I have to get a court order to order you to honor it. This really goes a long way to having the banks accept this form. Other attorney drafted forms, if it's not a uniform statutory form power of attorney, do not have this protection. But what is a uniform statutory form power of attorney? You're granting to a person, the agent, also known as the attorney in fact. We do not use the term attorney in fact. It is completely confusing. The client thinks they're naming the attorney, us, which is not the case. But you grant a person, the agent, in this case, Wanda grants Sally the legal authority to act on Wanda's behalf in financial matters. It can be narrowly tailored or broadly tailored, right? In the estate planning context, most of the statutory form powers of attorney are very broadly tailored, meaning they're kind of covering everything. But you may want to name a property manager, for example, to collect rents, right? So you might do a specific durable power of attorney for this property owner or the property manager to collect rents. Paying bills, picking up a registered letter, managing bank accounts, filing tax returns, selling or buying property, this is assuming it's not in the trust, or handling IRA and 401k investments is all under the power of attorney. It's flexible. You retain the right, if you make this power of attorney, you retain the right to revoke it at any time or amend the power, provided that you're mentally competent. So Wanda has a stroke. She's unconscious and rushed to the hospital. Wanda had named Sally as her agent, and once Sally's notified, Sally can use the durable power of attorney for property management and personal affairs to sign the hospital admission documents on Wanda's behalf. I'm conflating here the durable power of attorney for property management and personal affairs with the uniform statutory form power of attorney. We actually use both in our firm so that the uniform statutory form power of attorney gives you that hammer. The durable power of attorney for property management and personal affairs has the same agent, but much broader authority. Without the durable power of attorney, it will be significantly more cumbersome to handle Wanda's affairs. You may have to go to probate court. That would be a conservatorship. I would say budgeting on the first year of a conservatorship anywhere from $10,000 to $20,000 just for the first year on a conservatorship. There are court costs, significant court costs that run in the thousands of dollars, attorney and other fees the first year. Advanced Healthcare Directive, this is very, very important. Effective a quarter century ago, July 1, 2000, in California, the Advanced Healthcare Directive replaced and combined the traditional durable power of attorney for healthcare and the living will. So a durable power of attorney for healthcare said, I want this, Wanda says, I want Sally to make healthcare decisions for me. And Wanda says in her living will, if I'm a goner, pull the plug. That's kind of what a living will says. Don't, no heroic measures, no feeding tube, whatever it is. In 2000, California combined these two. And so I would say if your lawyer's drafting documents like it's the 1980s, you may have a durable power of attorney for healthcare and a living will. The more modern approach is the Advanced Healthcare Directive. So it authorizes a trusted person, so this is your healthcare agent, to make medical decisions on your behalf if you're unable to communicate those or make decisions for yourself. And it says under what circumstances life support should be withheld or withdrawn, a feeding tube, whatever it is. So that's covered in the Advanced Healthcare Directive. So make treatments, make authorizations. It's very important. This is not a POLST, a physician's order regarding life-sustaining treatment. The advance healthcare directive is not a medical order. It is a legal document. What is the difference? The advance healthcare directive, let me back up. Let's say Wanda was in assisted living and Wanda has an advance healthcare directive, but no pulse. If she stops breathing, the paramedics show up at her door and they start to resuscitate her. If Wanda has an advance healthcare directive and also has a pulse, which is that pink card in California, you may have this or you may know someone who has it. It says, and typically you tape it on the front door at the assisted living facility, if I'm not breathing, do not resuscitate me. That's what that says. So that's an order. Advanced Healthcare Directive is a legal document. A pulse is an order. So I know that's confusing for some people. But really the big question everyone asks is a will better than a trust? That really is the most common, like, well, Jim, you're talking. I still don't understand what you're saying. Most people are not avoiding planning in my mind. They're just unsure of what they really need, what's really for them. I will say if you own real estate in California or have assets over a couple $100,000, you really should be looking at a living trust for a lot of different reasons. The number one reason is it keeps you out of probate. So will versus a trust. A will is a list to the judge, not a whist. We need to change the W to an L. A list to the judge, meaning, Judge, I would like my property distributed this way. A living trust is instructions to the trustee, thou shalt distribute in this way. A will is public. You may not know this, but your will becomes a matter of public record. A trust is private. A trust is not mandatorily filed with the court or submitted to the court. A will must be submitted to the court within 30 days of death. Favors creditors. The biggie here is a will is structured after somebody passes away. A will is a creditor first procedure, meaning creditors are paid, then beneficiaries get the assets. A living trust favors loved ones and beneficiaries first and creditors second. And I'm not going to get in the weeds on how this works, but just understand a will is an open invitation for creditors to come in and, and then you kind of have to prove why you don't owe them the money, if you will. But a living trust is very focused on the beneficiaries and not on the creditors. They serve important but different purposes, and the right choice depends on your assets and family goals. If you really don't like your family and you want your creditors to get all the money, then do a will. So how do trusts work? It's like a bucket with a handle. So that's why we have a picture of a bucket here. You put your house, stocks, bonds, savings, mutual funds, investments into the trust. It's got a handle. When I die, I let go of that handle. The successor trustee picks up that handle, loses the moniker successor, and becomes trustee. So Wanda, right, when she was trustee, held on to the bucket. Then when she had her stroke, she let go of the handle. And now Sally becomes trustee of the trust and uses the assets in the bucket for Wanda's benefit. This excludes IRAs, 401ks, annuities, and life insurance. That does not go into the living trust. So that's one reason we need the durable power of attorney. So even if you have $1 million estate, even if you have a relatively small estate, it makes sense not to just have a trust, but you need the trust, the pour over will. And that's in case any assets are like house that's not in the trust, that should be in the trust. You want a will that leaves it to the trust. So you have a single place where assets are distributed from. All trusts have three things: a trustee, a beneficiary, and a corpus or stuff. If you're lacking one of these things, you do not have a trust. Right? Trust can take care of your assets while you're living. It avoids probate at death and incapacity. There are little used strategies. I really wish lawyers would use these more. I teach lawyers a lot on this. I think it's just too much of a lift for a lot of lawyers. They're like, it's too complicated. I just want to keep it simple. I'm going to keep my life simple. I'm looking at this and thinking, I want to protect my clients. So there are little used strategies that are available to protect your financial legacy from your heirs. These people who are inheriting from you, divorce, taxes, and lawsuits, and we'll talk about divorce. A revocable trust typically becomes irrevocable at death. Revocable, irrevocable, or irrevocable. So I'm changing the way we internally talk about it. It's revocable and irrevocable. So we're even changing the way we pronounce the word because sometimes it's hard to hear that it's irrevocable. But it's important to understand that a living trust is amendable until death or incapacity. So if a person's incapacitated by operation of law under California law, that trust is now an irrevocable trust, and the trustee has certain duties, and we cover that in other videos. Who ought to be successor trustee? Think about that. When you're gone and somebody's going to be running your trust, who should be the successor trustee? This person kind of has to be a Boy Scout or Girl Scout. Must be honest, organized and emotionally stable. You do not want someone who's dishonest, disorganized, and emotionally unstable. That is the worst person you could choose as trustee. You must be willing to say no to siblings, and that can be really hard for some people. Your oldest child is not automatically the best choice. Might be, but isn't always. Choose wisely. And I've told my kids this for many, many years. The most important decisions in life are not the how or the what. They are the who. Who you marry. Probably the single most important decision you're going to make if you become married in your lifetime. And for those of you who are married, you know what I'm talking about. Another really important decision is who is going to take care of you when you can't take care of yourself. As my Uncle Delbert said, can't do it for yourself. And who's going to take care of things when you're gone. Very, very important decision. Let's put the fun back in funding. Well, what am I talking about? Lack of funding is the number one reason estate plans fail. Funding is putting the stuff in the bucket, putting the house, the stocks, the bonds, the real estate into the bucket. How do you put a house into a trust? You do a deed. A trust without funding is a very expensive binder. It's a very expensive stack of papers because not doing anything. If the stuff isn't in the trustee has no authority over the stuff that's not in the trust. So I would say in terms of a checklist, deeds to all real property. That is how you fund the trust with real property. You don't just note that, oh yeah, this property's in my trust. It's a deed recorded at the county recorder's office. Bank accounts, brokerage accounts, so your investments. Any other non-retirement accounts, including business interest. This would be LLC, corporation, or partnership interest. So if you've invested in something, you want to make sure those interests are in your living trust. Otherwise, you're going to have an unfunded or an underfunded trust. IRAs, 401ks, annuities, stay out. Funding, again, funding is very important. And I said let's put the fun back in funding because truthfully, it's not very fun. I mean, there are a lot of other things that are way more fun than funding your trust. Let's be honest. But funding is not a one-time event. I think it's an annual check-in. In fact, my dad just reached out to me and he said, "Hey, can you?" This is what happens when your parents have an estate planning attorney. My dad says, "Hey, can you run a check on all these properties and see which ones aren't in my trust?" We did find one that wasn't, and it was a significant property. And that would have been a real problem if a property's not in the trust and my parents pass away. I'm going to have to go to probate court and fix it. And I'm the estate planning attorney, right? And I would have to go to probate court to fix that. So it's very important, get those properties in the name of the trust. And again, it's not a one-time event. Beneficiary designations are the silent plan killer. What am I talking about? This, again, estate planning mistakes. If this is you, and if you're watching this video because this is you, I'm really sorry. I don't even know where to start on this. The number one, and for you, by the way, this is a huge real world value add. An ex-spouse that is still listed on an IRA, maybe a 401k, maybe a life insurance policy. Under California law, when you have the final paperwork in a divorce, it is very clear. It says this person is not entitled to, let's say you leave an ex-spouse on an IRA, but you never get around to changing the beneficiary. That ex-spouse is going to get in the car and drive as fast as they can down to the advisor's office with the death certificate to claim that IRA, even though they're not entitled to it. Now, what can the family do about it? They can sue, right? They can sue the ex-spouse. But really, this is, I think, the number one thing we see when on messed up beneficiary designations is an ex-spouse still listed on the retirement account. So if you are married to somebody who used to be married to somebody else, you're going to want to check this one, right? This is good homework assignment. A minor child named directly, not a good idea if you have $1 million. Let's say you have $1 million in an IRA or 401k. Don't name your minor child directly. You should name some type of trust. And we talk about that in other videos. The IRA Legacy Trust or a living trust can solve this, but having the child named directly is real problematic. No contingent beneficiary. So if you say, well, I'm going to leave my IRA to my son, and if your son doesn't survive you, you should name a contingent beneficiary, because obviously if your son passed away, that's a big life event, and you would change your beneficiary designation, but you may not have capacity. You may have had a stroke or dementia or Alzheimer's or whatever it is. It's good to have somebody else after. So if your son isn't living, then it goes to somebody else. Naming my estate in beneficiary documents is a one-way ticket to probate, triggers probate. Naming my trust incorrectly. This is the wrong name or the wrong date or whatever it is. This is less of a problem, but sometimes the trust is not properly identified. And I will end with this slide. This is not a best practice to name your living trust as a beneficiary of assets in lieu of transferring those assets to the trust themselves. So we see this with some frankly lazy people. I'm not going to name names. But this might be like a financial advisor who says, I don't want to deal with this paperwork. I got to do a certificate of trust. Why don't we just name your living trust as beneficiary of this account? That's problematic for a lot of different reasons that we cover in other webinars, but that is a lazy way to do it. If it's a brokerage account, an investment account, it should be in the name of the trust. If it's a bank account, it should be in the name of the trust. Now, I can see use cases where, well, Jim, there's exception to this or exception to that, but I'm saying broadly speaking, it's better to have those in the trust than have the trust be the beneficiary. Trust funding and maintenance. Again, a living trust is not a magical event that happens once and you set it and forget it. You never have to think about it again. It's a tool that requires proper maintenance, right? Proper care and feeding. Signing is step one. Funding, getting the assets is step two, and keeping it updated is step three. So keeping your estate plan updated, typically annually. How to protect $1 million estate with estate planning. So benefits of a living trust, as we discussed, it maintains privacy, it protects your legacy, it avoids probate. But let's talk about why probate's bad in California. So time-consuming, 16 to 24 months. It is 4 to 8% of the gross value of the estate. If there is debt on the estate, it makes that number higher. So for example, I'll have a slide here. $1 million estate pays about $48,000 in attorney and executor fees and court costs. If there's $950,000 mortgage on $1 million property, by the time you sell the property and pay the realtor commissions and pay the lawyers, there's nothing left. So probate fees are effectively 100%. And again, it's not private. So probate in California, unlike other states, probate in California is a formal court-governed process. It doesn't mean we wear tuxedos and ball gowns to court, but it does mean that it's a very lengthy, long, drawn-out, complex process. And again, on $1 million estate, what we see here is the attorney's fees are $23,000 and the executor fees are $23,000. So if Wanda dies with that $800,000 house and $200,000 bank account, it's about $46,000 and 2 years, maybe a year to two. If her estate is, it depends on how backed up the courts are. Courts are kind of getting through, believe it or not, getting through the COVID backup, and it's been 5-6 years, but courts are now kind of returning to normal dockets and getting through that backup from COVID. But again, it's going to take you on average 16 to 24 months. Cost of planning versus cost of a mess. So you may be thinking to yourself, well, how much is this going to cost me? You get to decide. Do you want a probate and conservatorship risk and family fighting, or do you want a living trust plan coupled with periodic review to avoid all of that? Here's the deal. You pay more later or a lot less now. So it's pay a little bit now or pay a lot more later. I do want to mention Medi-Cal estate recovery and just Medi-Cal in general. We have a fair amount of slides on here. I'm going to kind of go through here and kind of hit the high points. But what am I talking about? Medi-Cal is California's healthcare system. And Medi-Cal says, look, if you're poor and you need to go to a nursing home, and let's say it's $13,000, $14,000 a month, and you have no assets, we're not just going to dump you on the street. You get to go to a skilled nursing care facility, not the greatest place to be, and the state pays, but you have to be poor. So you can have certain things, like we talked about Wanda. She could have an $800,000 house and and get Medi-Cal. The problem is if she does not have a living trust, when she dies, you have to pay that back. So if Wanda has a living trust, you don't have to pay that back. And so if they pay $200,000 for her care, the house is worth $800,000. She passes away, and then if there's probate, if there's no living trust, then the state is paid back that $200,000. By the way, half that money goes back to the federal government, and the state keeps half the money. The state did limit recovery only to probate assets. So before 2017, if you did a living trust, you still had to pay back, but now it's only for probate assets. And before you say, well, that's just California not collecting money, I think the latest figure was it cost the state more in administrative costs to collect the money because they're sharing it with the federal government than they were actually getting, and that's why they dropped the requirement. So it was more of a budgetary issue, I think, on the state level. So with Assembly Bill 1161, California reinstated the asset limit for Medi-Cal. So I mentioned you have to be poor. What is poor? You can have 130,000 if you're an individual. If you have 131,000, you can't get on Medi-Cal. I'm talking cash. There are certain exemptions. The home is exempt. The spouse can keep 190,000, 195,000. So if you have 250,000 in assets, you're 120,000 over the limit. Medi-Cal will say spend it down before we can give you any Medi-Cal. We've got some strategies to say, let's see if there's a better way where maybe you can do some gifting to accelerate your qualification. You can say that's the right thing to do or the wrong thing to do. It's certainly legal, and it's something that we do at our firm. I do want to mention the average private pay rate, which is the average cost of a nursing home in California, is $13,656 a month. That's a lot of money. That's if you end up in a nursing home. Child's inheritance and divorce. Let's talk about Wanda. She dies. Sally distributes the inheritance to Wanda's son, Johnny, outright and free of trust. But Johnny is divorcing Zena. So Johnny and Zena didn't work out. Johnny's inheritance, when he inherits this property, is separate property that is not subject to division at divorce. But an inheritance commingled with marital assets, let's say you deposit money into a joint account or use the money for joint expenses or both, that may become marital property, may become community property. So little red flag. But in our example here, even if the inheritance stays separate, and this is really important, please pay attention, a judge can consider the separate property of each spouse and looks at the total financial resources, not just the community property. Even though Johnny's inheritance isn't divisible as community property, even though Zena won't get her half because it's all Johnny's, it juices up potentially Johnny's support to Zena. So he might have to pay her more support because of the inheritance. So let me say this another way. An inheritance protection trust helps solve this helps. There's no guarantee. It helps because this money's not Johnny's. And certainly if Johnny's not the trustee, maybe Sally stays on as trustee. And there's a mechanism, we'll talk about that. Sally stays on as trustee. Johnny says, look, it's a trust. Sally can distribute the money to me or not. I have no say. I have no power over it. Judge, please don't include this in my support order to Zena. That's kind of what we're talking about here. Now, whether it works or not, I can't predict what a judge is going to do. I'm just telling you straight up, but it's better than nothing. I mean, I think here, if you're Johnny, certainly if you're Wanda, you never liked Zena anyway. You told Johnny not to marry her. This is the one way that Sally or that Wanda can set up her estate plan so that Sally can protect it for Johnny. This is very important. I mentioned Sally being trustee of Johnny's inheritance protection trust. So what we're talking about here is instead of Johnny getting the cash and having it stuffed into his pockets, it's in a separate trust. So it's like a caterpillar turning into a butterfly. While Wanda was alive, Wanda had her living trust. Then when Wanda dies, that trust goes through a metamorphosis, just like a caterpillar goes through a metamorphosis and becomes a butterfly. So what Johnny has is the butterfly. This trust that was Wanda's now becomes something else. It is no longer a trust for Wanda's benefit while she's alive because Wanda's dead. You can't take it with you. I cover that in the book. The Vikings tried it, but we'll see if it worked. Maybe. Inheritance protection trust. This is set aside. Johnny cannot get to the money because there's an axiom in creditor protection law, asset protection law. Whatever you can get to, your creditors can get to. Whatever pot of money you can reach your hand into and take that out, your creditors can do that as well. So Wanda leaves Johnny's inheritance in an inheritance protection trust for the benefit of Johnny, not to Johnny directly or as trustee of the inheritance protection trust. The inheritance is not creditor adjacent, it's creditor remote, and this helps Johnny argue exclusion from the support calculation. Either Johnny's never a trustee or he's removable by a trust protector. And a trust protector is somebody who has power over the trust but is not the trustee. Again, we covered this in other videos. Even in a state of $1 million. If you have a continuing trust, I really urge you to consider having a trust protector. This trust protector can remove Johnny as trustee and replace Johnny with Sally. And the reason that's better than Johnny resigning and appointing a trustee is it's kind of like whatever you can get to, your creditors can get to. It's weaker creditor protection. You want a third party, an independent, neutral third party, removing Johnny and replacing Johnny with Sally on Johnny's trust. This plan is designed to protect against lawsuits, judgments, and credit card, personal debt problems. Some divorce protection. I'm going to clarify here. It's helpful, though divorce rules are complex and they vary state by state. We don't know. Johnny could be a resident of Colorado. They have different rules in California. So it just depends on where you are. But I wanted to spend some time on this because even with now, if I'm inheriting $1 million, that's a lot of money. If you're Wanda and you're living in an $800,000 house and $200,000 in the bank, you're kind of cutting coupons and pinching pennies because you don't have much money. But when Johnny gets this $1 million, that's a lot of money for Johnny. So how to transfer $1 million estate with estate planning. So what is the transfer like? So what we're talking about here is Wanda's passed away. Some people call this dissolving a trust. The legal term is literally the worst term that lawyers could come up with because this is like almost like Orwellian speak. Trust administration. What does that even mean? What does trust administration mean? Nobody knows. It's a terrible name. Well, I'm an attorney. I know what it means. Most people just don't even understand what they're looking for. If you kind of do a Google search, or is you're looking for dissolving a trust. So what is the process of, what happens after Wanda passes away, after she's passed away, after, following her incapacity? The dissolving the trust administration manages the finances, collects the assets. Sally removes Wanda's name, puts Sally's name on, and Sally has to follow. Sally as trustee must follow the terms of the trust, the very specific instructions in the trust. Sally, as Wanda's successor trustee, is going to pay the debts and expenses, going to distribute the assets from the trust to Johnny, or maybe hold them in trust in an inheritance protection trust for Johnny. You see where this is going. It can take a lot of paperwork to transfer assets. Retirement accounts can be easy, but with the beneficiary designation. But in this case, Sally has no control or influence over that. Let's say Johnny is the named beneficiary on Wanda's IRA. Johnny needs to go in and say, here's my mom's death certificate, and I know she had an account here, and now let's get the process to get that over to my name. Bank accounts, they sometimes can be tricky, but they're manageable. It'd be tricky for a lot of reasons, but sometimes the banks want extra documentation. Real property and real estate can be very difficult, especially if you're trying to not have the property get reassessed, right? And we'll talk about Prop 19 and how that works in this section. So, a quick summary of Prop 19. It's a new rule everyone hates. It passed in 2020. Prop 19 significantly changed the rules for property tax reassessment when a parent passes away and a child inherits the property. When Wanda passes away and Johnny inherits the property, reassessment is triggered when there is a change in ownership. It used to be that typically your properties weren't reassessed when you inherited them from your parents. Now, generally, they are, with the exception of the family farm exemption, which is a per parcel exemption. So if Wanda had 10 parcels of farmland and all of those are under $1 million, there's going to be no reassessment. But there's a $1 million cap on a reassessment of property of Wanda's home. So if Wanda had an $800,000 home that passes to Johnny, Johnny has to move in within 12 months, has to file the appropriate paperwork. He should do that within 12 months. And then the property taxes in this case won't change because the exemption's $1 million and $800,000 is less than $1 million. So let's talk about this. So this is actual example from Zillow. This is a property in Los Angeles for $1.5 million. You can see here in 2023, the property taxes were the $624 a year. The assessed value was $35,000. It's like a used car now. But in 2024, the tax assessment jumps to $850, and of course the property is being sold for $1.5 million. But in 2024, the taxes jumped to $850, and so the taxes went up to $10,000. So Prop 19, very, very important for many people. These are the new rules, again, that everyone hates. Transfers to children and grandchildren typically now are reassessed. They used to be excluded from reassessment. The family home exemption lets you have a $1,044,000 assessed value cap. What does that mean? Well, that means that if you are a parent who dies and leaves a property to a child, the change in ownership is the date of death. So if you're the child, it's not when the property is transferred out of the trust, it's when your parent dies. You have 1 year to move in to the property, and you have 2 years to file the appropriate documentation. But if you don't file it within the first year, you are reassessed for that first year. So best practice is move in within a year, get your appropriate paperwork filed within that first year. And that's the form BOE, as in Board of Equalization, 19, as in Prop 19, P, as in parent to child. This is the intergenerational transfer exclusion. You also need to file your form BOE 266, which is your homeowner's exemption. You have to make that home your home. So move in, file your BOE 19P and your homeowner's exemption. So you claim the homeowner's exemption and your property taxes. Your property tax bill on $1 million estate shouldn't change because by definition, the property is worth less than $1 million, right? And your exemption is $1,044,000. And again, we cover this in depth in other webinars. We covered that. Oh, I do want to mention the reason I have this slide on here is a lot of people say, well, what if I tell the assessor that the property's, that old property, it's all beat up. It's not worth anything. It's not worth that. It's not worth $1.5 million. That thing's probably worth $600,000. Look at the terrible condition it's in. Or, my mom's going to sell me that property for $1. So that's the value. We're just saying it doesn't work that way. The assessor's office, whenever there's a change of ownership, that is the date of transfer. This is the date of death, the date of sale or date of gift, not date of distribution from the trust. Please, if you remember one thing from this whole thing, it is not date of distribution from the trust. The assessor says what the market value is. They give that information to the tax collector. The tax collector recalculates the taxes and sends out the bill. That's how the system works. It doesn't matter what your appraisal says. It matters what the assessor independently appraises that property at. So transferring a home after death, what if you want to give the house to one child? Planning ahead is usually the best option. So do you keep the property in the trust? You want to keep the property in the trust or the estate during the administration period. So a mistake would be if you want to buy out one of the kids, right? If one of the kids wants a property and another kid doesn't, we're talking about more than one kid, you don't want to just immediately distribute that property to the kid. You can have some real problems with that. So the parents structure the distribution. So what they've done is, in our case here, the parents have talked to the kids. Okay, who wants the house? One sibling gets the house. The other one gets cash or other assets. Let's say you have $1 million estate. There's $500,000 in cash and a $500,000 home. Provided the trust says that you can make a non-pro rata distribution. A non-pro rata distribution is not half the house goes to each kid and half the cash goes to each kid. That would be pro rata. I mean, most trusts provide this for a non-pro rata distribution. One kid can take the house, the other kid can take the cash. Now that works if the cash is at least equal to the value of the house. But in many instances, that is simply not the case. Certainly on $1 million estate, you may find that the house is the single largest asset in the estate. So what do we do? I'm going to kind of unpack this and walk you through the issue. And this is very important to understand. So if mom's, your situation, someone's passed away, a parent's passed away, multiple kids, one kid wants the home, the other one doesn't, but that kid wants to keep the low property taxes. So let's say mom leaves a trust worth $1 million. $800,000 is the value of the home and the investments are $200,000. And again, we're using Alice and Bob. Alice really wants the house. Bob couldn't care less about living there. He wants cash. So Alice is the sister. Her fair share is $500. Bob's fair share is $500, right? Because it's 50-50, but there's only $200,000 in cash. Alice is going to get the whole $800,000 house. Now, before the house is distributed to Alice, Bob gets the $200,000 investments and the trustee borrows $300,000 against the house. So let me say this another way. You've got a house of $800,000, a $200,000 bank account. Alice wants the $800,000 house, but there's not enough cash to make it 50-50. So the trustee borrows $300,000. Now, if you're in the lending business, you know what I just said is really hard to do because banks and lenders do not like to lend to trusts. They like to lend to people. But this is very important. This debt must be obtained on the trust level. So the trust borrows $300,000 in cash. So what we have is a slight change in the balance sheet. We have an $800,000 home with a $300,000 mortgage. That is $500,000 in equity. That equity is distributed to Alice. The $200,000 in investments and the $300,000 in the borrowed cash is distributed to Bob. That is how Alice avoids reassessment. If the property is distributed to Alice and of $800,000 and Bob gets the 200,000, and then Alice goes out and borrows 300,000 and pays Bob, $300,000 of that property will be reassessed. How you do it, again, you do it on the trust level. We have a whole webinar on this, and I believe we're coming out with an updated webinar for post-19. This is when the county assessor sees this as part of the inheritance distribution and not a sale. If it happens after distribution, it is seen as a sale, and you're going to have a partial reassessment. This is complex. The lender, trustee, and estate paperwork must all line up, and one wrong form and the assessor calls it a sale. If the sequencing is out of sequence, and in our case here, that would mean at least another $3,000 a year in property tax. Now, there are many people, $3,000 a year is not that much money. There are a lot of people where they go, if it's $3,000 a year, I can't continue owning the house. I just don't have the money. I don't have the money to live on. So very, very important, right? How to manage $1 million estate with estate planning. So, so you have this estate plan. Let's roll the clock back. No one's incapacitated. No one's passed away. And we have a little cartoon here. It's a joke. Well, yes, your will is beautifully written. I'm afraid a few of the estate laws may have changed since 1942. It's not looking good if your estate plan is outdated. It may not match your current life situation, your family situation. Follow the latest laws. It may have extremely negative tax consequences. We're seeing this with older estate plans, drafted before really 2010. Some of these have some really negative tax. They were written in a way to benefit people because the tax laws were different. But now with a $15 million estate tax exemption, it's causing some people, if you certainly are a married couple and one spouse passes away, it's causing a real big capital gains tax issue that we cover in other webinars. So trust reviews matter because if you don't do reviews, new assets don't get added. I mentioned my parents had a property recently that was out of their trust, and your estate goes to probate. Outdated instructions increase the risk for chaos for the trustee and the family. Beneficiaries fight because the trust no longer matches reality. Life changes, finances change, tax laws change. People get married, divorce, new baby, death in the family, a new house, you refinance, business, and you might get an inheritance. You might move to a different state. A lot of people left California during COVID. A lot of people are coming back. A lot of people leave California, come back for whatever reason. And that changes. You might have updated your estate plan while you were out of California, then you move back. Annual reviews, I think, make the most sense for most people. Just look at it annually. Who's my trustee? Who's getting what? We have $10,000 going to our daughter-in-law, and then our son and daughter-in-law got divorced, and we don't want to leave her that money anymore. So, take a look at that. Why estate planning matters. Why have an estate plan? We've covered a lot of the ins and outs. Remember, it avoids probate, can save taxes, and protect your legacy. So it begins with a Cunningham Legal initial consultation. In the initial consultation, we review your goals and risks. The lawyer identifies the planning gaps and priorities, and we explain to you options and recommendations. No decisions are required at this stage at the initial consult. I mean, certainly the decision to move forward with the engagement. Yeah, I know who my trustees are. I'm just not sure about, should I leave 10,000 each of my grandkids or not? It's okay not to have everything laid out. And it's really a continuum. Some people come in, they're ready to answer all the questions. Some people need a little more time. They need a little more reflection. The goal is a clear, workable path forward. Our goal is simple: to protect your people, your livelihood, and your plans so you can focus on living well and have peace of mind. Well, let's look. I'm going to walk you through what happens in a Cunningham Legal consultation. What happens? So what are the steps? Well, you reach out to us. You can reach out to us by phone. You can reach out to us online. A lot of ways to reach out. You book a time. Now, this is a free scheduling call with a client specialist. This is not a lawyer, who helps match you to the right attorney for your situation. A lot of people are calling for estate planning. A lot of people are calling for trust administration. A lot of people are calling for Prop 19 help. We have different lawyers helping clients whose practice areas are focused in that area. You pay the initial consultation fee, and they can walk you through what that is. It's a specific payment path set up for the initial consultation. You explain what you want to accomplish. So at that scheduling meeting, and then there's also an email exchange about, tell us more about what you, and hey, the more information, the better. Give us any documents you think might be relevant. It's really focused on your goals. This is not a generic checklist, and sometimes it's a back and forth, because what we find, because we do paid consults, we're not doing free consults, we get a different kind of client. Many people have come to us and they say, I've done 3 free consults. I'm not even getting an answer. Like, these people are just trying to sell me. It's a total waste of my time. That's not what we're trying to do. We're trying to help you, right? We're trying to get to the issues and see if there's a way that we can help you and maybe another attorney can help you get a path forward. The lawyer, so let's say you meet with the lawyer stress tests your real life. So you sit down, and this may be in the office, it could be by Zoom. These are typically 1-hour consults where we have a lot of information ahead of time. We review that information, review your questions, and so we come prepared to the meeting. We talk about your family structure and your dynamics. Dependent and caregiver issues, right? Are you taking care of anyone? Is someone taking care of you? Business and real estate realities. What does that mean? Your business, maybe you're looking to retire. Maybe you have real estate. You're tired of dealing with the rental properties. We're going to talk about that. These are a lot of these issues can cause probate fights, and we're trying to keep that from happening, really to give you ideally peace of mind. You get a risk and complexity assessment. So this meeting is designed to assess complexity and identify planning gaps. That's done in a conversational manner with the attorney, and you get a customized plan outline. This is the scope of representation. This is what we're going to be doing. Not legalese. This is not a template. It's a clear direction based on your California specific issues. You get next steps that are actionable. What to do first. So at the conclusion of the meeting, these are the things that we need you to do. This can wait. This can't wait, right? Sometimes in estate planning, some things can wait. Other things, you might think that's third order. We're going to say, well, that's something you might want to put up there first. Fee transparency, obviously, and engagement options. Obviously, disclosing what our fees are and how that works. Again, it's different for everyone, and so that's handled at the initial consult. If you hire the firm, then we shift into the build mode. We draft a custom set of documents. You sign them. We review them with you, we archive them, and then funding the trust and updating your institutional institutions, right? This is very, very important. This is putting the fund back in funding, and you leave with clarity and peace of mind. You have clearly stated goals and a workable path forward so that your plan protects you during your incapacity and your loved ones after death. That brings us to the end of our time here today. I want to thank you for spending time and making it to the end of the video, right? We have offices throughout Northern and Southern California. And if you're watching this on YouTube, please don't forget to subscribe to our YouTube channel. And we are now going to open it up for questions. We do this live. There are lots of people who are watching this video still on here, and we're going to open it up for questions. If you have a question, go ahead and put that in the comments field in our video, and I will endeavor to answer those. And if you're watching this on YouTube, keep watching because another video is going to magically roll up right after this one. Thanks for joining us.